Member of the full committee, Mr. Nadler.
Thank you, Mr. Chairman, for holding this important hearing. Mr. Chairman, not only do the creative arts serve to entertain and educate us, but they also support industries that contribute billions of dollars to the economy every year. Those industries exist because of the audiences that buy their final product. We as consumers want the inspiration, emotion, and diversion evoked by artistic expression. In exchange, we are expected to pay a fair market rate for those products, no matter the format in which we consume them. Intellectual property laws, including copyright laws, exist to foster creativity and innovation. They are a promise that with hard work and a lot of luck, you can monetize your imagination. But no technological changes challenge that promise like the advent of the internet. Even as technology helped us discover art beyond our small corners of the world, it made those creations easier to steal and thus less lucrative to produce. Copyright law is nothing without the ability to enforce those ownership rights. And it was with this reality in mind that in 1998, when the internet was still in its infancy, Congress passed the Digital Millennium Copyright Act, or DMCA, to protect copyrighted works online. But even with that landmark law in place, copyright piracy is still an issue that threatens industry stability and artists' livelihoods, and the problem is growing larger each year. I appreciate the opportunity to examine the issue of piracy, but as we consider any potential solutions, we should make sure we're looking at the problem not as it existed 25 years ago, but as it exists today. Copyright piracy now encompasses broad cybersecurity concerns, artificial intelligence considerations, and distribution changes like streaming services. Any action we contemplate must be flexible enough to stand not just the test of time, but also changes in technology that we cannot possibly imagine. Artists and content creators deserve to have their works and industries protected from illegal online piracy, and I'm grateful to Chairman Issa and Ranking Member Johnson for giving this issue the attention it deserves. With that in mind, I have a few questions for our excellent panel of witnesses. Ms. Temple, could you please help clarify the differences between IP address blocking, DNS blocking, and dynamic site blocking? When and how are each of these remedies useful?
Yes, thank you for the question. As I mentioned earlier, in most of the jurisdictions in which we operate, the site blocking order that is issued is flexible, so the ISP is just ordered to block access to the site, and the actual way in which that is done is up to the ISP. They might use DNS blocking, and they could use IP address blocking or URL blocking. In most cases, it's usually either DNS or IP address blocking. With respect to DNS blocking, it's typically, imagine, I guess, sending an envelope through the mail, and you have an address that you're looking for, and the ISP, the access ISP, is going to need to look for the address of pirate.com, for example, because they don't know the specific IP address, so they have to go to a DNS resolver and get the actual physical IP address, the 123.1.2.3.4.5 address for the website. And so in DNS blocking, the access ISP knows that they should not be going to look up the IP address for that site. Instead, usually they just disregard the request to go look up that site, so they can't get the address to that website. IP address blocking is similar, but it's looking at the IP address, so as opposed to the pirate.com issue, it might, if you know the actual IP address, the ISP will not actually allow access to the specific IP address that the website has. And then URL blocking is a little bit more complicated, but that is really they inspect the packet that's going over the internet and ensure that the very, very specific URL is not able to be returned back to the customer.
Thank you, Mr. McKnight. One of the primary challenges of enforcing anti-piracy laws is that the source of most pirated content is overseas. Could you please explain why this is significant and what policies, if any, can improve identification and enforcement of overseas actors?
So a lot of our enforcement efforts are actually based here domestically, because even though it is certainly true, as has been explained by my co-panelists, that a lot of the problem does start and originate overseas, A lot of the social media platforms and things like Facebook, Twitch, the usual suspects that we're seeing our content pirated over actually here is domestically in the U.S. So when we're looking for the definition of expeditious removal to be clarified, it's primarily to address that issue. The closing the streaming loophole, which was something that we got, you all helped us get past in 2020, has been tremendously effective. And I think with respect to that, it's all about enforcement. Domestic or overseas is getting enforcement against these career pirates, because unless they see folks actually going to jail or being shut down as a result of this legislation that's powerful and that's been enacted, they don't necessarily have a full incentive not to engage in the conduct. They pay attention to laws being passed. It's meaningful, it's helpful, but what's really helpful is when they see folks being caught and they see them suffering consequences.
Thank you. My last question is to Mr. Shears. Mr. Shears, sites hosting pirated content often endanger consumers through malware, cyber seams, and insecure connections. If, in your view, site blocking regimes go too far, how do you suggest we keep consumers safe?
So thank you for the question. Obviously, as I said, the best defense is a good offense, and making content widely available on as many platforms and in as many contexts possible is one of the first things that we need to do. Once we've moved beyond that, we need to look at inter-industry collaboration to ensure that digital services have the granular data and metadata about content to meaningfully pre-identify, for example, in the context of live streams, that something would be infringing, to filter upon ingest, and obviously strike arrangements such as those that I described earlier, where in some cases rights holders can choose to monetize instead of simply prevent. So there's a lot of options available. And then, of course, we have the existing panoply of remedies that are available under existing copyright law: statutory damages, actual damages, all the extrajudicial relief that's available under Section 512, to say nothing of technological protection measures and small claims. There's probably more remedies in the Copyright Act than many of our other IP laws. So we have a lot of robust tools at our disposal. There are many arrows in the quiver that we can use. To be clear, we're only raising concern about one specific arrow in one specific context when we raise concerns about DNS-level site blocking.
Thank you. Mr. Chairman, I thank you for your indulgence, and I yield back.
You have always granted me similar indulgence. I thank the former chairman and ranking member.